Good morning all. I am Sagar Shivas, student of first year of postgraduate teaching department of law. Welcomes you all to the national webinar conducted by postgraduate teaching department, Rashtrasan Tukaroji Maharaj, Nagpur University, on the topic of medical technologies and emerging socio-legal issues. Here are few general instructions for all the participants. Question and answer session will be conducted at the end. I would like to request to all our participants to kindly post their questions in the chat box and to get the recordings all of this webinar. Please subscribe to our YouTube channel. E-certificates will be provided within 10 days after filling the feedback form, which will be posted in the chat box at the end. Now, I would like to request Ms. Shivani Khandate ma'am to give the theme setting of this webinar. Over to you, ma'am.
Thank you, Saga. A very good morning and warm welcome to all of you. As rightly quoted by Arthur Clarke, any sufficiently advanced technology is equivalent to magic. Due to advancement in modern medicine and technology, newer and more effective methods of cure and treatments are available that will be helpful for humans to live longer and healthier. Medical technology is the application of science to develop solutions to health problems or issues such as the prevention of delay of onset of diseases or the promotion and monitoring of good health. It is important to govern medical technologies and ensure its appropriate lawful use for the benefit of the society. As medical technology is advancing at a very fast pace, it is giving rise to certain social legal issues pertaining to it. So, to enlighten us on this topic, we have with us Professor Dr. Jyoti Bhakre ma'am. I welcome you, ma'am. Over to you, Sagar.
Thank you, ma'am. Now I would request Dr. Payal Thare ma'am, Head of the Law of the Postgraduate Teaching Department of Rashtrasan Tukaroji Maharaj Nagpur University to deliver welcome address. Over to you, ma'am.
Thank you, Sagar. Respected Honorable Professor Dr. Jyoti Bhakre ma'am, all the dear participants, my colleagues and friends, a very warm welcome to all of you on behalf of Postgraduate Teaching Department of Law, Rashtrasan Tukaroji Maharaj Nagpur University. Today, Madam, I would like to share with you that today is the last webinar of our 10 webinar series, and I am very happy to inform you all that we all had a wonderful series wherein lots of new topics were discussed, and today's topic is the cherry on the top, that we are today discussing about the contemporary issues which are there in the medical technology field. And it is really our pleasure to have Dr. Jyoti Bhakre ma'am today, because she is the expert in this field and she is known for her command on law, health and medicine. And I extend my heartfelt thanks to Jyoti Bhakre ma'am for graciously accepting my invitation for today's webinar. And we all are looking forward to hear from Jyoti ma'am on this contemporary topic. So thank you so much, ma'am. Over to you, Sagar.
Thank you, ma'am. I am glad to introduce our eminent resource person, Professor Dr. Jyoti Bhakre ma'am, Head of the Department of Law, Savitribai Phule, Pune University. She has completed her LLM and PhD, and she has professional experience of 29 years. After completion of BSL LLB with first class, she joined the legal profession as an advocate and handled various cases. She has expertise and consultancy in the field of medical negligence litigation, legal aspect of healthcare management, healthcare law and policies. She is a member of World Association of Medical Law, a nominated member of Focus Group for examining the medico-legal aspect for Center of Excellence in the field of integrative healthcare and research in oncology, sponsored by Ministry of Ayush and Government of India. Legal advisor to the Government of Maharashtra on legal issues in the medical education and health policies, and also legal advisor of some of the hospitals in Maharashtra. Law member of Institutional Ethics Committee of National Center of Cell Science, Pune, NCCS, Government of India, and law member of Institutional Ethics Committee of National Institute of Virology, Pune, NIV, Government of India. Contributed editor of Nagpur University Law Journal and Law Journal of Shankarrao Chauhan College, Pune. Approved guide for PhD. 6 students has completed PhD under her guidance. She has published 48 research papers, both national and international. Author of the book named An Introduction to Healthcare Law. Research project from 2014 to 2016. She had undertaken a research project on impact of legal regime on hospital administration as a critical analysis. And from 2017 to 2018, she has completed an interdisciplinary research project in law in Sanskrit, changing dimension of women property under Hindu law from ancient to modern Indian context. Once again, I welcome you, ma'am. Please enlighten us over this topic.
Okay, thank you so much. Am I audible properly? Uh, because I
Yes, ma'am.
had some issues when ma'am was speaking. While ma'am, when you were speaking, I had some uh, voice breaking
Yeah. But
hearing
ma'am, you
from
are
your side.
audible now. You are
Okay, okay,
properly
okay,
audible to us.
okay. Okay, because I have started one system, I have kept the other one ready. Just let me know in case there is some connectivity issue or to that
Yeah,
effect
sure.
if any corrections are needed in making the system work properly. Okay, thank you so much. Thank you for your kind and generous introduction, I would say. And first of all, before I start with the topic that is been given to me, I would like to congratulate Payal ma'am and all her team for having successfully conducted the series of such webinars that really goes beyond our class teaching, and it helps not just our students, even the students from other faculty as well, and that is really required to be appreciated. Even we may also in future bring such kinds of series here for our students from other faculties as well. So that's really a good thing I learned from you. Okay, at the outset, I would like to thank Payal ma'am for having invited me here to give some time for me to think over as to what I should do for these students. And then that is how we chose the topic medical technologies and emerging social legal issues. So once again, thank you so much for having invited me here, giving me opportunity for being here with the staff and the students, at least online, because this is now the generally accepted mode of our interaction. Being there, rather it has some disadvantage of not having that direct connect and interaction, but let's try to make it. So I would like to thank Shivani ma'am for having coordinated this event, and then my earlier student who is now the faculty of this department, Dr. Girish also, and all other staff. Thank you so much for having called me here. Okay, let me go back to my topic, medical technologies and emerging socio-legal issues. Shivani ma'am in her introductory speech has already talked about how the medical technologies are emerging day by day, and then how they are really leading to various kinds of socio-legal issues. I would like to bring to your kind attention that in this August gathering, when the students of law as well as sciences have come together, this interaction should go further, because we really need these science people to have advancement not just in the area of sciences but even in the area of law. And of course law needs to be there in every sphere of life, not just for regulation, even for further development as well, and that's why the law and science people need to go together. Okay, coming to medical technologies, as I already said, that technologies are evolving so fast that law cannot catch up that speed. We have to identify this reality. Technologies emerge, the research, the speed with which the research is carried out and with which the technology is actually brought into the market, the application of it, and all this is emerging with a very high speed. And what happens to law? We have to identify certain issues. After we identify the issues, we think, okay, we should have law on this, and then we make some draft, and we know the parliamentary process how it takes place. Okay, so then some draft will be placed before the houses, and then the houses will discuss on that irrespective of whether they are expert on this or not, and that is how the bill comes in the form of a law, okay, in the form of act. Is that the way we are supposed to handle the technologies, especially when there is misuse of technologies? All such questions come to mind, and it is always seen that the laws don't develop with the speed with which the technologies and the sciences progress. Then what's the solution? If both of them can't match with the speed? Does it mean that technology should not go fast? Does it mean that the law should go faster? What is that? Okay, in this gap, there is something. That is what the legal principles are. Okay, especially in the areas of sciences and biological sciences, there is a different branch, interdisciplinary branch, that is the branch of bioethics, that has developed and that has addressed many of the issues that are arising out of the misuse of such technologies, may it be biotechnology or may it be any other technologies. Okay, these principles need to be studied, especially when the law people think about how to regulate this technology when the act is not passed by the parliament. So that's why the principles of bioethics can help us a lot. When it comes to medical technologies, we find that especially 20th century has progressed a lot when it comes to discovery of DNA structure, then various kinds of experimentation, which we earlier labeled as human experimentation, and later we termed it as clinical trials. With all these processes, we acknowledged that there is gross human rights violation. And when there is gross human rights violation, how should that be curbed? And is that just human rights violation or any other else? That also need to be thought over. Coming to this, you can look at this particular slide. You might have heard about this eugenics. It's a branch of knowledge which evolved especially in 19th century in all European countries, including even USA and Japan, and to some other parts of South America and even Asia. But it evolved as a great branch of knowledge, especially in Europe and America. If you see the roots of this tree, you may find here, you can find anatomy. My cursor lies here: anatomy, biology, physiology, psychology, genetics, mental testing, anthropology, geology, history. You just name and that branch is there. And this is just one side of the picture. To the other side, there may be some other branches also. You just name, I would say that becomes the basis of development of eugenics, and it was considered to be a very developed field of knowledge in 19th century, which was further taken to 20th century, especially after means that was the period during First World War and post First World War. This eugenics had assumed a great importance. Any master's course or graduation in this particular branch would be considered very important, and this was one of the branch that has further developed to the path towards human experimentation as well. This was one of the forces behind the scientists to think of as to what is right, who is expected to be there in the society, because in order to bring out best progeny, such kinds of experiments were conducted as would promote best progeny and as would demote the worst. Darwin's survival of fittest would also support such kind of experimentation, and ultimately what it led to so many such kinds of experiments and further developments of in the field of law. So when we think of medical technologies, we may trace the history. Of course, we need not go to ancient India and medieval India due to paucity of time, but in modern era, we can trace this history from eugenics to transhumanism or posthumanism in the modern era. Okay, and this has interwoven the chain or interaction between genetics, law, and human rights, and so on. So, the practice of advocacy of improving the human species by selectively mating the people with specific desirable hereditary traits ultimately today is seen in the form of sex selection, is seen in the form of ART, assisted reproductive technology, is seen in the form of even sex determination of fetus, which is banned today by law. But how did the people reach out to such particular stage? There were the forces of eugenics prevailing at that time. So with this, we may reach to the stage of transhumanism. I don't know how much I would be able to cover in this particular lecture, because generally in my biotechnology law lectures, we take more than a month to cover all such technologies. I would just throw light on some of the technologies today in my lecture. You can look at this. Perhaps the science students must be knowing this. About Nazi human experimentation, you might have watched a number of movies and documentaries on this as to how the doctors, especially Dr. Karl Brandt and his team, had conducted the clinical trials. Today, we term it as clinical trials. At that time, it was human experimentation on many innocent people, including even the fetuses and even the children and various categories of people. Perhaps you won't be able to bear such kinds of pictures, but if you Google about Nazi human experimentation, you can get how many kinds of experiments were conducted, how were they conducted in Nazi concentration camps and all that. This was a gross violation of human right. See, this is one of the pictures from such concentration camps. Okay. This was from Auschwitz camp. And that ultimately was taken to the International Court of Criminal Justice, and then this case, United States of America versus Carl Brandt, and of course there were many doctors involved in this. This was known to be a doctor's trial. This was the case that was rather the foundation for human rights jurisprudence in the later period. The law that developed out of this trial came in the form of Nuremberg Code. What is this Nuremberg Code? Nuremberg Code lays down the principles regarding informed consent. Perhaps in law you might have studied about informed consent, which is entirely different from consent in the conventional sense. Okay, and you can see here, I am not going to discuss each and every principle, but these principles were laid down in Nuremberg Code by way of informed consent, which has become a law almost all over the world. And informed consent is a very, very necessary procedure in doctor-patient relationship. And not just in doctor-patient relationship, even in clinical trials. Today's almost all jurisdictions in the world have developed their laws in tune with this code. Rather, they have the laws that would require informed consent to be taken up in case of all interventionist kinds of research. Especially in case of science research, you might have heard about informed consent and pro forma of informed consent and how it is to be taken up. I happen to be an international certificate holder regarding this, and I happen to work on many medical institutions that work in this regard, in NIV, NCCS. These are central government institutions where we law people need to be there in order to train the researchers about how, what is the importance of informed consent, how it is to be recorded, because in absence of informed consent, there are a number of social legal issues arise. And this was not just Nuremberg Code that was relating to this. If you see the history of such human experimentation, you may find that almost all developed countries have committed the crimes relating to informed consent. And they have committed the crimes not just in their territories, they have committed such crimes even in the developing countries by treating the subjects, the citizens of these developing countries as subjects, guinea pigs. Okay, Tuskegee syphilis experiment is one of such experiments that was conducted during the period between 1930 to 1970 on the colored people in US, when there was penicillin available that was not used, and the people were told that they were being treated for bad blood. And then the people were injected with some microorganisms relating to, of course, virus relating to syphilis, and then they were not treated properly. Rather, they were left without treatment in order to see or study the severeness of the disease, whether it leads to death, whether it leads to severe injuries, to what extent these injuries would be severe, and all such kinds of experiment was conducted over them. At the end of this, at the end of it, means it was not actually ended. One of the say volunteers and even the doctors came out to media to disclose what was going on for last 40 years. And it was revealed that nothing came out of this study. And then that is how this experiment was stopped, for which in 1997, the then president of America, Mr. Bill Clinton, had sought apology that it was gross human rights violation. So this happens to its own citizen in USA. And you may find a number of such examples all over the world. So the question is that the technology is progressing, how far it is controlled? Because till then we didn't have any law to control this. Rather, after Nuremberg Code, Belmont report came up, some other regulatory mechanism started coming up in certain jurisdictions. In spite of that, such experiments were vehemently conducted all over the world, including India, I would say. You can take the example of thalidomide disaster. Thalidomide is a kind of drug that was developed during the period of Second World War, and then it was on a very large scale used for certain diseases like, say, morning sickness. Later it started being used widely for say cough, cold, and such kinds of diseases. Okay, and it was found that when they were used upon pregnant women, the children that were born were having severe deformities. This picture can be seen where almost more than 10,000 children were born with such kinds of deformities. Out of that, 3,000 died and the rest of them still survived with all such defects. And after almost 6 decades, the German inventor had issued an apology. In spite of the laws being there, this was prevailing. So we have to see what is the gap between law and reality. This gap also gives rise to many legal issues. Why the law is not effective? Why the law is not deterrent? And what needs to be done in order to make the law effective? The question first is whether the law exists in order to curb such kinds of practices. Now, when we speak of technologies, there are so many such technologies. The major question is as to uh, how and where to identify the issue associated with it. Because many people think that okay, ये तो practice है, ऐसा ही होता है, मेरे साथ भी हुआ, इसके भी साथ हुआ, ये होता ही है. So what is wrong in that? That wrong element in it is very difficult to detect, because many a times neither doctors nor the subjects are aware about the wrong element into it. And that's why so many questions do arise because of lack of knowledge. Okay, I would give some example. With technology, what has happened is the life is being prolonged beyond the natural course. For example, you can take the example of say mechanical ventilator, which is used as a life prolonging treatment in hospitals, in especially intensive care units. And then many a times it is seen that such ventilators are very expensive, and that's why in order to get them occupied regularly in a routine manner and to recover the expenses, it is alleged that many of the times the patients, even though they are dead, they are still kept on ventilator. Okay, when somebody comes to replace him, then the person's ventilator is withdrawn, and till then it is continued. Sometimes it is seen that the consent of the other people are taken, say those who are eligible to give the consent on behalf of him, their consent is taken, and then how exactly and what happens inside ICU is never known to the person who actually gives the consent. So the question about use of such mechanical ventilator is how far, how long should it be used? Because many a times at the time of insertion of the ventilator, patient is alive, but when the time to remove it is arising, who is to take the decision? The doctor cannot take the decision. The patient is not in a position to give the consent. Then somebody else has to give the consent. And how far such consent is valid? I have handled some such cases. There was a case in which a woman was kept on ventilator. She had met with an accident and then she was put on ventilator, and she had strained relations with the husband. She was to file a divorce petition against the husband. But when she was on the deathbed, the husband said that he has changed his mind and he wants to be very good to her, and he insisted not to remove that ventilator, whereas the parents insisted that the ventilator be removed and then she should lead a peaceful death. Okay, now the question before the doctor is whom to listen to, whether husband or whether parents, whose consent is to be taken. That can't be answered by the existing law, and that's where certain complications do arise. Such questions are not answered by the existing law. Then when there are conflicting opinions, what is to be done? Okay, many a times it is also seen in many countries that in order to harvest organs, because organ trade is again a negative side of such kind of technology of organ transplantation. In order to procure organs, many a times in a hurried manner, the brain death is declared. How can you put curb on such kinds of practices? There are many ethical issues associated with it. And that's why if you see the overall development of medical law, especially with respect to technology, you may find that the ethical considerations or the bioethics principles have provided the basis to development of law. Even in case of assisted reproductive technology, about which I am going to talk during the course of this lecture, there are many questions which are unanswered by the existing or non-existing law, I would say. And that's why we may find that, okay, you just take one technology and find that, okay, there are these many problems associated with that. And when it comes to technology, the one who invents technology perhaps has not anticipated such kinds of issues. It is the human being who always thinks of the other side of misuse of such technology, and there comes the role of law. Okay, I was talking about bioethics principles. There was a theory, of course, there are many principles which can't be covered here, deontology and so many principles and the branches developed out of that. But this theory, especially from law point of view, is very important for us. This is the theory of principalism developed by Beauchamp and Childress. Okay, this gave rise to 4 principles. The principles of autonomy, beneficence, non-maleficence, and justice. What does it mean? Principle of autonomy. Today we talk about consent. Then further about informed consent. We talk about right to privacy. All these emanate from this principle of autonomy. What is to be done with my body? I have full autonomy to decide whether to withdraw life support system or whether to extend it, whether to give the consent or not, whether to deny the treatment or not. That's my autonomy. So much can be talked about principle of autonomy. This itself has gave rise to many sections in many laws. Beneficence, the research or any kind of treatment should result to the benefit of the patient. I just cover it short. Non-maleficence, at least it should not create any harm to the one who is subjected to it. And justice, the principles of equity should be followed. Justice really need to be brought out of this. For example, I would say there is some clinical trial going on in which the subjects are taken for as volunteers for that experimentation, and these subjects are always generally found that they are poor, and that's why they are involved into it. And when the experiments end and the technology comes in, who are always the beneficiary? Those who can afford it. Because when the result comes out of it, those who bring such results apply for patents, then it is commercialized, and of course many a times it becomes expensive, and it can be afforded to only those who can have money. So what about those who have volunteered in such kinds of experiments? They just become guinea pigs. Can justice be rendered to them? During COVID-19, you must have seen that many companies or even the research institutions develop vaccine, and a very good decision was taken by almost all of them about non-patenting of them in order to give the benefit to majority of the population all over the world. This happens in a very, means at very rare occasions it happens. Otherwise, there is always debate between human rights to one side and IPR to the other. I'm not at present getting into this. So with these principles, so many laws evolved. What I was saying, at international level, there was Belmont Report, Helsinki Declaration, then the international ethical guidelines for biomedical research involving human subjects, and based upon that, even in India, ICMR guidelines developed, and all these branches in the area of medical law, like medical termination of pregnancy, PCP/NDT Act, Human Organ Transplantation Act, the Supreme Court decisions on euthanasia, and there are many other areas, like say xenotransplantation, clinical trial, assisted reproductive technology, stem cell therapy, genomics, genetics, all these are at present governed by such ethical principles. We don't have law on all the subjects. So how do we govern? We govern on the basis of these ethical principles. All over the world, these principles are accepted. Okay. Now let us come to some interesting questions relating to law. These questions arose out of the use of technology, especially in the area of biological sciences, and we as the law people look at it by wearing the lenses of law. And when DNA technology has evolved in order to determine so many things, especially in order to connect the criminal with the crime, in order to connect parenthood with the children, and in so many things, overall in administration of justice on a very large scale, it is used. But what about such samples? Who owns it? For example, I am holding this bottle and I leave it here. I go in a hotel, have some food or drink some water. I leave my DNA samples on that glass and somebody uses my samples. Do I own those samples? Is a big question mark. Can that person have access to those samples? Okay. So what kind of property lies in such kinds of biological material? We law people need to look at it from that point of view. I'm not going to answer all the questions. Okay. I'm just raising certain questions from law point of view in your minds. Okay. This is about randomly left DNA samples. Can they be used in investigation procedure? Or in order to procure the samples, we need to take the court permission in this regard? Does it so happen that police first of all connect such samples, and then when they reach out to the criminal, then once they identify him, once they reach out to him, then again in order to make that proper in legal framework, they seek the permission of the court? What happens in reality? We need to think over. Okay, same may happen about blood, urine, human organs. We give our blood or urine to the labs for investigation. What do they do with that? Generally, we think that they must be disposing them off according to the rules of biomedical waste and management. Do they do that? Or what else do they do with that? They store our reports. Do we own those reports? What do we have any ownership right over our reports? Or what kind of right do we have over our reports when they are in the custody of the lab? If they share this data with somebody else, okay, you might have read about the PIL that was filed before Supreme Court, Swasthya Adhikar Manch. Okay, that case happened in Madhya Pradesh, where the clinical data of the subjects were shared by the doctors with the pharma companies. And there, that was the first case, and thereafter the Medical Council of India, then existing Medical Council of India, had to amend its regulations 2002 in order to be in tune with the decision in that PIL. So such questions really do arise. The same questions may be with respect to such biological material, maybe sperms, eggs, embryos. These days we find that there are sperms or eggs banks. Okay, so these banks are in many of the cities, and the people donate sperms and eggs. There are many such cases of wiki donor over there. Some do it for the sake of money. Though the word donation is used, there is commercial element associated with that. Okay, that is one part. Okay, I need not get into that part at present. But if it comes to the business of such banks, how do they deal with them? Okay, how long and how far in what quantity can they store such sperms or eggs or embryos? For example, if some of them are used and some of them are not used, how long they can preserve it? How long they can use it for commercial benefit without the knowledge of the one who has donated? So many such questions. These days, many of the young people, uh, they means especially the couples, they donate their eggs and sperms, rather donate instead of donate, I would say they avail of the services of such banks in order to store their sperms and eggs with a desire that whenever they in future want to be the parents, they would use these eggs and sperms. And this is a reality. And I was under the impression that this was the reality. Of course, a few years back, I was thinking that it is just in developed country. But here in Pune also, I have seen now such examples in these days. Okay, because they want that the sperms and eggs in the early age would be rather more powerful when they want to be the parents somewhere in 30 plus age. So for example, by using such sperms and eggs, an embryo is created, okay, and such multiple embryos are kept in such banks. Okay, one embryo is inserted into the couple. What about the rest of the embryos? Dhanda hai. They may use it for insertion into some other couples. Okay, I mean the women. And they may mint money on this. So can they do this legally? Our law people need to view such kinds of circumstances. What is written in the agreement? Because we don't have laws on many aspects of such kinds of situations. So I happen to handle such kinds of agreements with some clinics here in Pune. And many issues are associated with this. I happen to handle a case in which an NRI couple from USA had come over here in Pune based hospital, and the IVF treatment was going on. The material was procured from USA itself. Okay, and we have 1989 rules about procurement, handling, and storing and such kinds of materials. Okay, under the Environment Protection Act, we have 1989 rules. Okay, so under which it was brought over here, and the first cycle failed, second cycle failed. When third cycle was to be entered into, there was dispute between the husband and wife, and the husband instructed the hospital not to go for such IVF cycle for the wife. Okay, and it was written in that agreement that it would be governed by US law, and US law would say that permission of both of them are necessary. So in such a case, when the permission is withdrawn unilaterally by one person, what is the remedy to the other one who is left helpless in such a situation? Law people need to raise such questions, and of course they need to seek the remedy in case of such situations also. Okay, when the law means the agreement is made in USA, when it is it is to be governed by US law, when it is executed in India, and his doctor, that is Mr. Goldie was the doctor, he had removed some blood and the components of blood from his body over all these periods and develop a cell line. And after he developed a cell line, he sought for the patent, and he got the patent on it, and later he commercialized, he used it for commercial purposes. When John Moore came to know that it was based on my biological material, he said that he is entitled to get some benefit, or say the consideration from that as well. So the court denied. The court said that when such biological material is removed from your body, it doesn't means it doesn't remain to be the subject matter of ownership for you. Of course, this judgment was given with the dissenting part as well. It was given in 4:3 ratio, and the court held that you can't claim it as of right, the commercial part of it, but of course you can sue for breach of privacy and for breach of fiduciary duty, but you can't get the commercial benefit derived out of it. So many such cases are there. In Miss X versus Mr. Z, that was the case decided by Delhi High Court just few years back, 3 to 4 years back. So in that case, there was a woman who was pregnant, and she wanted to abort the fetus, and that's why I went to the hospital, AIMS, okay, and got the abortion done. When the husband came to know about it, he applied for the information as to whether he was the father. Okay, DNA sample he required to take and want to confirm it. So he sought the permission for that, to which the wife objected and said that it is breach of her right to privacy, and the DNA samples cannot be taken because the fetus was removed from her body, and it was a part of her body. So she has ownership over that body part, and then the husband can't access without the permission of the wife. This was the case in which the High Court held that when the body part is removed from your body, then it doesn't remain the ownership, means the ownership doesn't remain with the person, means with the wife, and that's why the husband was entitled to take the information about the DNA sample, and then further about the fathership of that particular person and not. Okay, so such interesting cases come to be developed. Okay, Havasupai tribe, you might have heard of, that is a tribe that lives in Grand Canyon region, Arizona state, from USA. So there was a university, State University of Arizona. They had taken the blood samples of this tribe, and they were told that they were being treated for diabetes, and their samples were used for various purposes in research. So when it came to the knowledge of this tribe, they sought for $7 lakh compensation. Sorry, they sought for 50 lakh dollar compensation, to which, out of which 7 lakh were granted by the court. Again, the same thing here. When the sample was taken, there was lack of informed consent. The persons were not disclosed as to the purpose for which such samples were to be used, and then this was the breach of trust also, and on this count this was done. So many such cases on this particular uh, point itself, about whose property right it is, we can talk a lot. Okay, now about this ART, so many interesting cases are there. This was a case in New South Wales Supreme Court in Australia. The wife wanted to have sperms of course, wife and husband had decided to extend their family, and meanwhile, all of a sudden, the husband met with an accident. The wife wanted to remove the sperms of the husband. Can she seek such permission? Is she entitled to removal of sperms after the death of the husband? If yes, then within how many hours should it be removed? Such questions were there, and in this case it was held that the husband also didn't have ownership over the sperms, and that's why the wife also cannot claim the ownership, but the husband has possessory interest over the over the sperms, and such possessory interest is inherited by the wife, and wife is entitled to have the possessory interest over the sperms, and that is how she was entitled to get them removed even after the death, and within 48 hours such procedure was carried out. This happened few years back, almost 3 years back. Recently a Kolkata High Court judgment came similarly on this. The husband met with an accident, and a wife wanted to be pregnant by using the sperms, but the father of the husband was not allowing this. He approached the high court saying that the wife cannot claim to get the sperms because that is our progeny and that is the right of our family. The court didn't accept his contention, and court held that only widow has the right to get those sperms. Just 1 year back, this judgment came. Okay, so many such judgments are there. I won't be able to discuss all of them with paucity of time. When it comes to regulation of egg or sperms, okay, n number of judgments, cases, and principles evolved. Rather, ART is such a branch in which I have worked a lot, and number of experiences in case of ART, especially related to social legal to one side and ethical to the other, number of instances. Okay, so this is about donor agreement. When multiple sperms are donated, who has right over them? And not just about ownership over that biological material. Can the father have right over the children born out of this, and vice versa? So a law is developed in India. It's not that developed. Of course, today when the Surrogacy Act has come up just few months back in December, in the month of December 21, it has been said that he is not considered to be the father. Only the commissioning parents would be considered to be the father and mother. But when it comes to rights of the donor, there are many laws developed at various levels. Okay, there are children's law, then there are some other guidelines developed in some other jurisdictions, and some rights are given. For example, there is a donor, he has a right to meet the children, and the children born out of such donor arrangement are entitled to know about who is their father. Okay, to such extent the laws are developed. And the question is, do these rights extend prior to birth and after death? When I am saying, for example, it's the fetus. When he is in the mother's womb, we have a restricted set of laws in India. But with the technology coming up, such existing laws are always now questioned. For example, what are the fetal rights? And if we see the ethical principles of the law developed so far in this regard, it says that the mother has the preemptory right over the fetus. Okay, so in this regard, may it be relating to right to privacy, may it be relating to right to life. Okay, such questions are always decided in favor of the mother. But now recently, the American Convention of Human Rights has identified the fetal rights also to some extent. So at present the law is one-sided. There was a Dublin Declaration on maternal health. Here it prioritizes, for the first time at international level, it prioritizes the fetal right to life by noting that there is a fundamental difference between abortion and necessary medical treatments that are carried out to save the life of the mother. Okay, even if such treatment results in the loss of life of her unborn child. So what is this? If there is some negligence committed by the doctor during that pregnancy period, whether a fetus can ask for damages after having taken birth, we have not developed that law to that extent. But if you go to UK, yes, they have a proper law on this, and based upon torts, on the principle of negligence. Now, I was talking about the technology that was used during the stage of pre-birth. What about post death, do we have any such kinds of technologies? You might have heard about cryopreservation, where the liquid nitrogen is used and the body or body parts are preserved in a very low temperature, almost minus 196 or whatever is required for that particular purpose. This is a technology by means of which it is said that the life is suspended. And such technology is being used in some labs and clinics in USA, Russia, and few some countries, even Germany. So what happens here? Here the body or body part is preserved in liquid nitrogen with an objective that in future, whenever the technology is evolved, the life can be invoked into them. Okay, can you understand? This is really going against the course of nature. But many people have registered for such kinds of cryopreservation. And at present, more than 1,000 people all over the world have gone for such kinds of preservation. This can be a very interesting topic to be discussed for some other time. Now, my questions are about so many issues that are associated with it. For example, there would be issues associated with privacy. There could be issues associated with autonomy. There may be issues associated with the protocols to be followed by the clinics when they go for such cryopreservations. There are issues associated with the contract that is entered into between two persons. For example, today I enter into such contract with the clinic. By the time I die, I don't know what would be the situations. Who would be left to interpret it? It is just the other side of the contract. That is the clinic. They would be deciding as to what and how much does the provision of the contract mean. And that's why commercial contract, entering into commercial contract, execution of such commercial contract, breach of such commercial contracts is very much a big issue in this area. There are some practitioners working in this particular area in such jurisdictions. Okay, there are many such issues. I'm not going to show you this documentary. Let us see some pictures. You must be knowing that she was Miss World and she gave birth. She was from India, Hyderabad. She gave birth few years back, almost 5-6 years back. Okay, to twins after using 8-year frozen eggs. You must have heard about Wikidonor or you must have watched movie. There are many such Wikidonors all over the world, even in Pune and elsewhere. So what about their rights? What about the rights of the children? I talked about it. Okay, in UK, again, by applying the principles of eugenics that I showed you in the first slide, the people who are dyslexic, the people who have some kinds of deformities, maybe physical or mental deformities, they are denied for the donation of sperms or eggs. How far that is to be advocated, especially in the era of human rights jurisprudence. This question really becomes a legal issue and social issue as well. In infertility industry, so many issues are there. Right from sex selection to designer babies, commercial use of sperms, eggs, embryos. Some of them I just mentioned before you. Even about leftover embryos. What is to be done? Okay. Various countries have various laws on this. This is an interesting picture you can see. Nadia Suleiman. She was an octomom. You can see she was 33, single. She had already given birth to 8 babies. And my question was relating to the liability of the doctor who offered her services. Okay. Rather, she should have been refused for such kind of treatment. But she came, conceived, she was not able to bring up the children in a proper manner. She was living on social security measures. It is the liability of the doctor. What about the right to life of the patient as well as children? You can see this picture. What about those helpless children? And who would exercise their right to life on their behalf? Who would do it? Will the doctor accept any liability? So in ART, such questions arise. How many embryos are to be inserted? In case few of them are inserted, then whether the good one are to be kept alive and the bad one are to be aborted. What about the questions, ethical questions about the right to life associated with these embryos? Because embryos are having life. Okay. Such questions are unanswered in the existing laws. You can see here, look at all these questions. I won't be able to discuss everything. Okay, in this regard, you can look at this picture. Pig and human hybrid. This picture was developed by a Korean artist, but it won't be far from reality soon. Because in 70s, Onco mouse was developed. You know what is Onco mouse? That is a mouse with a human ear on it. In order to treat some cancerous patients, such Onco mouse was developed. And later, many such rather animals were developed. Okay, recently there was some xenotransplantation related experiments also. In xenotransplantation, you must be knowing that the pig organs, majority on a majority scale, they are used for being transplanted into human beings. What about the animal rights? Who is to protect them? Do we have any law on that? If the animals are used just for the selfish purposes of men. Okay? So such questions are unanswered by the existing laws. Even recently, almost somewhere near 2000, there was a rhesus monkey in which the jellyfish genes were sliced jellyfish genes were introduced, and then that was experimented upon on the same way the oncomouse was generated. Okay, now in this way, uh, this technology is moving in such a direction which is not controlled. How is and to what extent can it be controlled? And that's why in this regard, the protocols need to be developed. They are in the process of development, and the law people need to look at it from this legal and ethical point of view. And that's where today research ethics has become a very important part everywhere in the field of development of technology. Genomics, okay, again a branch where you can see here in slides, I have given some examples in which, in each of one of which, there are legal issues associated with that. Now, perhaps you may ask, what are the social issues associated with it? I would say that everywhere when we think that the technologies are developed, many a times they are misused. And in all this process, there is always some disparity in such a way that those who are poor, those who are vulnerable are always subjected to such kinds of vulnerability, especially women, prisoners, disabled people, poor people. They are always subjected to such kinds of experiments. That is what the history of clinical trials say. And of course, during all such stages, the benefit is derived by some people and it is left to the other people to suffer from it. So this kind of situation prevails everywhere. So this also gives to social issues. Then associated with this, for example, when such a trend is evolving, especially suppose in the area of ART, what happens to our social issues when it comes to the fabric of family, parenthood, children, overall the relations in the family, the relations in the society. Certainly it has certain social issues associated with that. Of course, though there are ethical and legal as well. In this regard, I just run the slides because now we are running against time. You can look at this Universal Declaration on Human Genome and Human Subjects, especially after Human Genome Project that was completed in USA. Many issues came out of that, and then based on that Human Genome and Human Rights related Universal Declaration came up. Okay, neurology, neurotechnology today, I can't complete it, but I just run some slides. There are many legal issues associated with this, especially when we talk about right to privacy. Right to privacy and neurosciences is a separate branch of biotechnology law, I mean. Again, associated with many human rights issues as well. Transhumanism, human enhancement, okay, pervasive technologies, disruptive technologies, and all these technologies have so many legal issues associated with that. Okay, with use of AI, artificial intelligence, AI, in so many such I would say investigating technologies, and then even in treatments, especially in medical devices that are coming up with these enhancement technologies. How should that be controlled? Okay, so when we are coming up with healthcare by use of AI, we need to address many such issues that are coming out of that, especially in the area of radiology, pathology, neurosciences, genomics. AI is coming up very fast. You can see the example of here Xenobot. What is this Xenobot? You might have heard about robo and robotic technology in the area of healthcare. But this is a Xenobot which can procreate. In 2020, that was evolved. So it can evolve life forms, and this can be used for the treatment purpose as well. This is environmental friendly, safer for human health, and it can be inserted into human being. It can be used to clean up radioactive waste, to collect microplastics in oceans, and for various purposes. So this was a new invention that has again opened up the Pandora's box. Okay, then there are many such conventions wherever the human rights violation is there. Almost in all such cases that I have talked about, human rights violations are associated. And that's why Oviedo Convention was introduced in 1999. Then in 2003, International Declaration of Human Genetic Data. We talk a lot about data protection, and the bill was to be introduced in last session. It could not be, but then perhaps in next session we may have the bill passed on data protection. And what about the personal data protection? What about the healthcare data? We have Disha, okay, for healthcare data protection, but that is not enough. So of course that is based on International Declaration of Human Genetic Data. Okay, this was just an overall view about the medical technologies and the issues associated with that. I leave it now to you to ask me any questions. You may mail them to jyotibhatre@gmail.com, and with this, I think I should stop.
Thank you, ma'am, for giving your insightful knowledge over this topic. Now we will move to our question and answer session. There are few questions I will be asking one by one. The first question is, can you please share
Can
your views and opinion?
are they there in chat box? If they are there, I can
Yes,
see.
ma'am, there are in chat box.
Just a minute.
Sagar, you can ask the question
Sure, ma'am.
and ma'am will answer them.
Okay, okay.
The first question from the student is, can you please share your views and opinion if in the case there occurs some kind of medical negligence due to technology, who would be liable? Shall I repeat again?
Yes, please. Yeah, I couldn't hear your question.
Yeah, the question from the student is, can you please share your views and opinion if in the case there occurs some kind of medical negligence due to technology, who would be liable?
Okay. Uh, Regarding medical technology,
Right.
okay. I happen to handle a case where there was use of robotic technology here in Pune. There was a surgery, and during the surgery, the robot went uncontrolled. The surgeon who was sitting here, and the robot was being operated by a biomedical engineer. Okay, the company had sent an engineer in order to operate that robot. both of them both of them were there in the operation theater, and it was being monitored by another surgeon sitting in some other city. I think he was from Chennai. And then there was some mechanical problem with the robot. So the question was, when the patient suffered, who is to be held liable? Because the patient has entered into contact with the doctor. He is the patient of that particular doctor. He is the patient of that hospital. He has nothing to do with that robo, with that company and all that. The company's customer is the doctor. Okay. So can the company be held liable for that negligence? Because there is no patient-doctor relationship between that between that company and the patient. Doctor-patient relationship was between just the patient and that doctor. So whose liability it is? To what extent the doctor can be held liable? This was the question. Does the doctor have any control over the robot? That was another question. Okay. And in this case, means the case is still pending, but this is not clear from the existing law that is evolved on medical negligence in India. When there is manufacturing defect or any operating defect in the robot, then who is liable? The doctor can sue the company for manufacturing defect or operating defect. But can the patient go against the company? The answer is no. So we have filed a case against the doctor. Because after all, the doctor is accountable to the patient. Okay. So we are fighting that case, and the doctor is saying that it was not his fault. There was no lack of care, because in medical negligence, what one has to prove, there was doctor-patient relationship, there is duty of care, there is breach of that duty of care, there was breach of the standard that is supposed to be exercised according to Golem test, and that standard was exercised. But then we have to show that there is breach of duty, because we are not going to see as to whom you procured. Okay, so we are still fighting for that case. This is the recent case based on technology that I happen to handle.
Thank you, ma'am. This is another question. How can we justify the human cloning when the clone's organs are circumcised to be replaced with the master's? Does it infringe with the right of life?
So far, nowhere in the world human cloning is allowed. For experimentation, yes, it is allowed. But for commercial use, nowhere it is allowed. For therapeutic use, it's not allowed.
Thank you, ma'am, for your answer. There's another question from a student. It happens to be for the COVID-19 case. We are hearing it uh, that any new vaccine has to be tested for years together, and the side effect of such vaccine may come out at least for 2 years. But in the COVID-19 case, vaccines are developed in 8 to 9 months and administered. Is it the violation of human right in putting millions of lives in the risk?
A very good question. Here, for all such clinical trials, at international level, there are GCP guidelines that are required to be followed. Means that is considered to be the standard guidelines. Based upon that, in India, we have ICMR guidelines, and each country has its own guidelines. Now, in case of COVID-19, it was considered to be an emergency situation. And in emergency, WHO, along with many of the governments of the countries, they waived strictly following with those protocols or those guidelines. Because of such waiver, they could bring that vaccine into market. Okay. In some cases, some vaccine companies disclose the data. In many cases, it was never disclosed, especially in case of Johnson and Johnson, Pfizer, they never disclosed that data. Okay, so this happened. And that is whether it is gross violation of human rights, I would say that in emergency, certain things are excused because emergency always becomes an exception. In order to save majority of the public, if some rights of some minority are violated, then it is justified by principles of bioethics. Okay, so in that case, the public rights override the private rights. That is how the bioethics principles justify it, and that is how, and as it was emergency also, it was allowed.
Thank you, ma'am, for your answer. The last question is, what are your views on prenuptial test being carried out? Would it not be amount to infringement of privacy if shared before getting married?
Prenuptial
Prenuptial tests.
prenuptial test, what kind of test?
Uh, it's sort of a virginity test or something like that.
Virginity
Maybe
test doesn't
blood
have
test.
anything to do with technology.
Okay, sure. That was all the questions from the students.
Okay, thank you.
Now I would like to request Ms. Shavani Khandade, the ma'am, to deliver the formal vote of thanks. Over to you, ma'am.
Thank you, Sagar. Respected Professor Dr. Jyoti Bhakre, ma'am, Head of the Department of Law, Savitribai Phule, Pune University, Dr. Payal Thavre, ma'am, HOD, Postgraduate Teaching Department of Law, RTM, Nagpur University, faculty members, my colleagues, and dear participants. Once again, a very good afternoon to all of you. I, Shivani Khandate, on behalf of Postgraduate Teaching Department of Law, express my deep sense of gratitude towards you, ma'am, for sharing your knowledge and experience in field of medical technologies and law. Thank you, ma'am, for giving insights about the journey from eugenics to transhumanism, referring various medical disaster experiments in the history, impacts of technology, ART techniques, medical negligence and law, rights of unborn, and crypto preservation, and many much more information, which would definitely be helpful to our participants. We are thankful to you for sparing your valuable time for this event. I am thankful to our head of the department, Dr. Payal Thavreman. It is because of you, your positive encouragement, madam, we were able to successfully organize this webinar. The technical team headed by Mr. Abid Khan sir, deserves a special mention and thanks too. I would like to express my thanks to the student coordinator, Mr. Sagar Srivas, and all the volunteers involved in the webinar. And also sincere thanks to all the participants for joining this webinar. Thank you all, one and all, for your support in making this webinar a success. Thank you once again. Please note the feedback link has been posted in the chat box. Kindly fill it.
Thank you so much. Thank you, Shivani ma'am. Thank you, Payal ma'am, Girish sir, and
Thank you,
all
madam.
your
Thank you so
team
much.
Thank you,
for
ma'am.
giving a patient listening.
Thank you. This video will be available on our YouTube channel, that is Law Department RTMLU YouTube channel, and all the participants and others also, they can view this video on our YouTube channel. So we will be sharing the link with you as well, ma'am. Once the recording is uploaded, I will share you the link for this webinar.
Thank you
Thank
so
you.
much.
Thank you, ma'am. Thank you so much.
Thank you.
Yeah. Abid sir,
Thank
please
you, ma'am.
share the YouTube channel link with the participant. Someone has asked for it. Oh, yeah, we have already shared it. Participant, please make a note.
Thank you. Can I leave?
Thank you, ma'am.
Thank you.
At last but not least, I would request everyone to please turn on the camera as we would like to take a snap.
Oh,
For all the participants, please turn on the camera. Thank you so much. And from this, we will be ending this meeting. Thank you, ma'am. Thank you for joining us.
you are welcome. Thank you, Payal ma'am. Bye.
Thank you, ma'am. Thank you so much. Thank you.